Begin with our opening ceremonies. Jared, you bring the torch.
Yes.
How about you lead us?
Okay, sounds good.
Pledge allegiance to the flag of the republic, one nation, indivisible, with liberty.
Thanks for that. Next up is a roll call.
Commissioner Hoffmeister,
Here.
Commissioner Houts, Commissioner Leininger,
Here.
Commissioner Collins,
Here.
Commissioner Schaefer,
Here.
Commissioner Stoll.
Present.
Thank you.
So up to the approval of the agenda. If you had a chance to check that out.
I make a motion, we approve the agenda as presented. Second.
Okay, we have a motion with support. Is there any discussion on that? Changes or anything? Hearing none, all those in favor say aye.
Aye.
Opposed? All right, carries. How about the minutes from our February 27th, 2025?
I have moved to approve the February 27, 2025 meeting minutes as presented.
Support.
Okay, we have a motion with support. Any discussion on that? Sure, it was a great meeting without me here.
And I'm sure you were enjoying the weather where you were.
It's nice. It's really nice. Any other discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? All right, motion carries. All right, we're up to our Open Meetings Act presentation from Andrew. Thanks for being here.
Good morning, everyone. Andrew Breggy for OZ that don't know me. My firm has been serving as general counsel for the health department.
Your laptop's at.
My laptop's having issues.
Presented for you.
Yeah. Okay. It's typical for the technology to be the problem. But we've been serving as general counsel for the health department for decades now. And so it's that time of year, or rather that time of every couple of years after the elections, where we're going around and doing the Open Meetings Act presentations. And it's your turn. And Teresa also asked if I could add in some stuff on conflict of interest, because I know that that's a topic that's come up a few times in the past. So we've added some things into the presentation on that at the end.
It was your laptop.
What about this TV though?
That TV's on.
It's half the laptop. Everybody just needs to turn and look this way, I guess.
So,
If we can't figure it out though, it'd be nice for the folks that are in the back.
No, impossible.
We're not going to.
Not going to be possible.
Not going to work.
You can see my, it's very small. Well, just as a precursor, there are 99 slides. I'm going to try to get through this all relatively quickly. I know some of you have sat through some of these presentations relatively recently. So I will do my best to get through it. If there are questions that come up during the presentation, feel free to chime in, ask a question. If it's something I know that's already coming up, maybe we'll move on to that, or we'll take the question right there. Looks like we've got it working now on both sides. So, all right. Brief overview of the Open Meetings Act. The Open Meetings Act is a statute that requires all decisions of public bodies to be made at meetings that are open to the public, with a very few limited exceptions. And it provides both civil and criminal penalties for violations, which makes it very important. And those apply, the criminal side at least, to the actual members of the board. The purpose is to promote openness, provide greater public access and accountability, and public input into the decision-making process. The Open Meetings Act accomplishes these goals by requiring public bodies to conduct their meetings at open meetings that the public is able to attend. Now, what is a public body? It is a very long definition according to the statute. It is any state or local legislative or governing body, including a board, commission, committee, subcommittee, authority, or council that is empowered by state constitution, statute, charter, ordinance, resolution, or rule to exercise governmental or proprietary authority or perform a governmental or proprietary function, yada, yada, yada. That's a really long way of saying that the Branch Hillsdale St. Joseph Community Health Agency's Board of Health is a public body. So you don't need to worry about the long definition, just know you fit that definition. You are empowered by statute, the state's public health code, created through our enabling resolution to be a public body. Which means, as a public body, we're bound by all of the rules included under the Open Meetings Act. What's important to note is that public body also includes any subcommittee that this board establishes, if that subcommittee is given authority to deliberate towards or render an actual decision. So it's not just when all of us meet together, but it's if you delegate authority to a sub. Now, there's some very recent decisions from the Michigan Court of Appeals as related to marijuana regulations that have indicated that if you delegate to a single person, that single person can somehow still be a public body. Doesn't make a whole lot of sense to me, unless we're getting into one of those situations of being John Malkovich, where we're all going to get inside of somebody's head. But just note, delegating what could be the agency, the full body's authority to a single person can be viewed as avoiding the Open Meetings Act. So it's something that we should try not to do, delegating full authority to one person, if that's a decision that needs to come back to the full board. The Open Meetings Act does not apply to a committee or a public body that simply adopts non-policy making resolutions, tributes, or memorials. And it doesn't include purely advisory committees that are less than a quorum of your full board. And it also, and this is the important one, doesn't apply to a social or chance gathering or a conference or a training session that is not designed to avoid the Open Meetings Act. So it's okay for, people to show up at lunch sometimes, as long as when you show up to lunch, it wasn't previously coordinated for the sole purpose of, hey, let's go deliberate at the diner, as opposed to doing it at a public meeting. So even if you have one of those chance encounters, make sure you try to avoid the actual business talk while you're at that chance encounter. A meeting means the convening of the public body at which a quorum is present for the purposes of deliberating towards or rendering a decision. What is a quorum? A quorum is the minimum number of members required to transact business. Sometimes those minimum numbers are set forth by statute. Sometimes they're set forth by your enabling resolutions. If we don't have it set forth in some regulation or statute, we fall back to the general idea that a quorum is a minimum majority. So half plus one, so that you can take action. Here, we have a 6-member board. Half is 3. You really can't take a lot of action with just 3 of you, because that's less than the majority. Good.
So if we only have, today there's only 5 of us here. So our actions require 3 votes or still require 4 votes to enact?
It depends on which action it's going to be. Some actions based on either statute, some of those actions would be covered by the Open Meetings Act, and we'll get to some of those, require a supermajority, which there are certain provisions in the Open Meetings Act that will require a 2/3 vote of all active members, regardless of whether they're present. But otherwise, if there's nothing in a statute, regulation, or our own internal policies that require something, it's just going to be a majority of the. So today, you'd only need 3 to take action if there's only 5. If it doesn't fall within one of those other requirements that has a supermajority or something of that nature. Fair? We're talking about video and telephonic attendance. I don't have to spend a lot of time on this because this is the old law. Prior to COVID, it was allowed that we could have video or telephonic attendance for board members to attend meetings in order to get us to that quorum. As long as there was uninterrupted communication, two-way communication for the board member to hear everything that was going on, and for everyone at the meeting, including the public, to hear what was going on with that board member. But that was pre-COVID. Then we had COVID. And right before COVID happened, though, there was some changes with the statute to specifically address that. But COVID removed those authorities after the essential emergency went away. So there was a period of time during COVID where we were allowed to have some level of remote attendance. But then they took that all away. And now remote attendance is only allowed when there's a member that's in active duty military service. When a member has a medical condition that's not COVID related, or we are in a quote statewide or local state of emergency or disaster that would risk the personal health or safety of members of the public at that meeting. But sections 2 and 3 had a sunset that ended in January of 2022. So I don't know why they haven't just simply removed them since they sunsetted, but that's Lansing for you. So really, under the statute, the only remaining provision is the military provision. But that doesn't really end everything, because we also have the Americans with Disabilities Act and the Persons with Disabilities Civil Rights Act, which are the two, which is the state law equivalent. And in a 2022 Attorney General opinion, our Attorney General held that public bodies must offer reasonable accommodations for members with disabilities. So we can still have the possibility that a member can have remote attendance if that's a necessary accommodation under the ADA or the Persons with Disabilities Civil Rights Act. Shortly after that Attorney General opinion came out, there was a lawsuit filed in the Western District of Michigan. So in Michigan, we have our state courts and we also have our federal courts. The federal courts that govern where we are is the Western District of Michigan. So it was the chief judge of the Western District of Michigan that issued this opinion, which means that if we were to face that similar situation, we would probably be bound by that same decision. And she ruled that, so an Attorney General opinion is just advisory, but she actually ruled and issued a preliminary injunction against the Clinton Eaton Ingham Community Mental Health Authority that they were required to provide an accommodation to a board member that had a disability to allow the remote attendance. So it supersedes and overrides the limitation in the Open Meetings Act itself. Now that wasn't a final order, but when you issue a preliminary injunction, you got a pretty good idea on who that judge is going to ultimately rule. And that issue was resolved before a final opinion came out, but pretty confident she's going to rule that same way in the future. So that leaves us now with two different things. Member in the military, or if there's a member that has an actual disability under the ADA or Persons with Disabilities Civil Rights Act and requires remote attendance as an accommodation to that. It's going to be a rare situation, but if it comes up, it is something that the board would have to take into consideration for that member. Now we move on to deliberating. This is a term that is not defined in the Open Meetings Act, but the Open Meetings Act does require all deliberations to take place in an open meeting. The courts apply a common sense definition to what deliberating is. They call it when you're discussing, you're considering, when you're exchanging views, when you're debating a matter. That's what they consider as to be deliberating, when you are getting towards rendering a decision. Now, deliberating takes place in many forms. This statute was passed back in 1976 as part of a nationwide package of sunshine laws that were a direct reaction to something that happened at a hotel involving Richard Nixon. Back in 1976, things like that we're using right now and looking at didn't exist. Your cell phones didn't exist. iPads didn't exist. None of that stuff really existed. We didn't have more technology and computing power in the palm of our hand that was required to land us on the moon, if you believe that. Just kidding. So where this gets us into trouble is deliberating can often take place outside of a meeting, and you might not even realize that it's something that could be considered deliberating. That's when you're emailing as a full board, exchanging deliberations, sharing views through an entire email chain. It can be just texting each other or even just texting a couple people. That's why in a best practices, what we don't want to do is ever hit reply all if all of the individual board members' emails are on one chain. Or another good practice is when the email goes out to the full board is simply blind copied on it, so they don't have the option of hitting reply all. Because once you start hitting reply all and exchanging views, now you're potentially deliberating. That becomes a problem because anything you guys are sending through email is subject to a whole other statute we're not going to talk about today, but I'm going to bring up. It's called FOIA, the Freedom of Information Act. Another one of those sunshine laws that we can thank President Nixon for. And when someone sends a FOIA request, they get those things, then they can establish, oh, look, you guys were deliberating in emails. And emails are obviously not something that takes place in an open meeting. That's where things can become a problem. Social media can also be a problem. My advice on social media is just avoid it. But I know that that's never going to happen. So what you need to do with social media is avoid getting into a debate with the rest of your board members on social media. The things that you post on social media can also have other implications, such as First Amendment implications, which is beyond the scope of our meeting today. But if anybody happens to be going to the Michigan Township Association meeting next week, I can teach you all about that fun stuff. But avoid anything that's going to keep an electronic record to show that you were engaging in rendering decisions, exchanging views on policy things that are for the board outside of an open meeting. So here's an example I like to use of how the technology ended up hurting somebody. This is somebody on the eastern side of Michigan from the People's Republic of Ann Arbor, I jokingly referred to. They had a city council member who was himself an attorney at the time. And he, back in 2007 and 2008, there was this big issue that had to do with an environmental concern. But this news reporter started sending a bunch of FOIAs that didn't have anything necessarily to do with what was really going on in the open. It was on this other topic. But when they got this newspaper reporter was able to look at the timestamp of these emails and text messages and go, wait a minute. They were in a meeting when that happened, which meant that some of the board members were emailing each other during the meetings or texting each other during the meetings. So obviously engaging in secret discussions during the meetings. Most of the stuff that ended up coming out had nothing to do with anything substantial, but it was produced under FOIA. Like at one point, one guy was saying, I mean, there were some bad things like, hey, I'll vote for this if you vote for this. I mean, those are backdoor deals taking place in secret. You shouldn't be doing that. But the other things that were just stupid were like, I can't believe Cat Lady is still talking about this topic. In specific reference to one of the other council members that was sitting at the meeting. Well, that all blew up in the newspaper right before the primaries. Guess who didn't win his primary? And it lost by 6 votes. So maybe that person still sitting on the council had all of those things not taken place. So make sure that you're not doing those things. If the email, text, social media discussion could be considered as bearing on one of the issues that needs to be taken up by the board itself, could be considered deliberating. So avoid doing those things. You don't want your constituents to know that you're having secret deals when we're all supposed to be here at the public meeting. In all of those technology examples, the procedural requirements of the OMA were not followed. Which then brings up, well, what are those procedural requirements? The first procedural requirement is notice. Every public body must provide notice of their meetings, and every notice must contain a certain number of things. That must contain the name of the public body, the telephone number, if one exists, and the address. Always be posted at the principal office and any other locations considered appropriate. Cable television can be used to post your notice as well. For all of your regular board meetings, Those must be posted within 10 days after your first annual organizational meeting for your fiscal year. So it's either the calendar year or your fiscal year, whichever you use as your organizational meeting. If you're going to make a change to your regular schedule, those changes must be posted within 3 days after the meeting that your change is made. For all regularly scheduled or special board meetings, the public meeting notice must state the date, time, place of the meeting, and shall be posted at a minimum of 18 hours before the meeting in a prominent, conspicuous place at both the public body's principal office and this is statutory language, really, really, really long way than the legislature said. If you have a website, you must also post it on your website. I love the legislature. Whenever they can use 4 words, they choose 4. But that's a really long way. If you're going to post everything, post it on your website. If you're going to have a special meeting, you must post those on your website.
And Andrew, to me, the key thing is this, it's gotta be on your homepage, or it's gotta be on a conspicuous link on your homepage that
Right.
goes to it.
Absolutely.
It can't be just hidden out there on your website, it's gotta be prominent on your webpage.
Via a prominent and conspicuous link on the website's homepage that clearly describes its purpose for public notification. That's language right there in the statute. So yes, right on the homepage. Now, what's good about you guys is your staff already takes care of that for you. They do a really good job of that. So don't worry about that part for you. Same thing with the notices. Your notices go out and are appropriate. If a meeting happens to be recessed for more than 36 hours, day and a half, you have to simply repost and basically follow brand new meeting notice procedure. Something that's not going to happen very often. If for some reason we have an emergency meeting, which is in the event of a severe and imminent threat to the health, safety, and welfare of the public, and 2/3 of the members determine that delay would be detrimental to the efforts to lessen or respond to that threat, you can waive the 18-hour notice. That's going to very, very rarely come up. But in the event it does, you need to make paper copies of your notice that you're going to have at that emergency meeting. I mean, if you can't wait 18 hours, yet you still have access to printers and things like that to make paper copies, seems a little odd to me. In that notice, you must explain in detail the reasons why you can't comply with the 18-hour notice. You can't simply just restate it's a severe and imminent threat to the health and welfare of the. You still then must post it on your website. So again, if it's such a severe threat, you still have access to your website and printers. Apparently, you still have everything available. It seems odd that you gave that 18-hour notice, and then you must also send a copy to each of the county boards of commissioners. So you guys are a 3-county department. So you can't meet your 18-hour notice. We can put it on the website. We have access to printers, and somehow someone's going to drive to all 3 different counties and deliver it to the county boards of commissioners. So again, an emergency meeting that waives this 18-hour notice is not something that's likely to come up. But like I said, in the event it does, you can't just simply repeat the statutory language on imminent threat. You actually have to have a very specific reason. And compliance with that section does not provide a legal basis or defense for failure to comply with the other provisions of the Act, i.e. that your decisions would still need to be made, in public. You can't have email discussions or things of that nature. Now, with notices, the public can subscribe to notices for a yearly fee. I have never seen that come up where someone has asked for a subscription to your notices. And especially now that we have them all posted online and with certain FOIA provisions that specifically tell people if they ask for public records that are available online, we can just point them to the website. This is something that, again, very rarely, if ever, comes up. They must be made available to all local newspapers if they request them, along with radio and television stations, free of charge if they're requested. So now we got notice out of the way, let's move on to the actual meeting issues. Again, only have the meeting if we make sure and know that proper notice has been given. Meeting fundamentals. All meetings shall be open to the public and shall be held in a place available to the general public. That means can't have the meeting at Vice Chairman Leininger's deck in his backyard that he doesn't allow everybody in the world to come to. So I don't know if the deck's in the backyard. So.
Well, let's just say it has brand new cover on it because we had to do that for the wedding that was in the front yard last year, so.
Fair enough. But it needs to be in a place that's open to the public, not hidden from the public, not closed doors. All persons shall be admitted or permitted to attend the meeting unless they commit a breach of the peace at the meeting. So you can't have a freestanding order to block certain people from the meeting. They can only be removed if there's a breach of the peace at the meeting. The right to attend meetings includes the right to tape record, videotape, live broadcast those meetings. If there's going to be someone that wants to videotape, they do not have to get prior approval before they can record and live broadcast those things. But if we have our own rules established, we can put regulations in place about how those things take place. So if we have rules and regulations, we have what anybody that's a fan of the band called the Grateful Dead, they used to have a thing called the tapers section. So you can set up a rule that says, all right, videotaping can only take place over here so as not to allow people to disrupt the meeting. So someone can't be walking around with their camera during the meeting and doing this kind of thing. Set up regular rules for so that it's not going to interfere with your processes. Again, all of your decisions need to be made at a meeting open to the public. This also includes decisions that we can have discussions at in closed session. The actual ultimate decision needs to be made in the open session, whereas deliberations might be able to take place in those limited circumstances. But the decisions need to be made at the open meeting. The deliberations outside of those covered by these special exceptions must be made in the open session of the meeting. Persons do not need to provide their name or other information as a condition to attend a meeting, which means you cannot force them to register for their attendance. But you can ask them to, and that if they refuse, that's not a breach of the peace. But you can require them to give their information if they are going to be providing public comment, because you have an obligation to take accurate minutes. Now, when it comes to the public comment provision, there are a lot of rules and regulations that we can impose. The statute itself doesn't set a whole lot of specifics on that, other than anyone that wants to is allowed to talk at the public comment. Under the statute, every meeting is required to have at least one public comment meeting. You internally can have rules to have multiple public comments. That's all up to you. But what you can't do is put an overall time limit on all public comment. So you can't say all public comment must take place within 30 minutes. But you can have a rule that says individual public comment can only be 2 minutes or 3 minutes or 5 minutes. Whatever your rule or regulation is okay to limit individuals. You can also have rules in place where you request that people that are going to simply be repeating or making the same comment to all just join together and say that it's all one comment. You can do kind of things like that. What's really important, though, during public comment is making sure that it is the public making the comment. It is not an exchange or an opportunity for you as the board members to start interacting with the public, because that can be viewed problematic in a number of ways. First, it could be viewed as potentially interfering with their public comment. If they have a time limit and you engage back and forth with them and you're taking up some of their time, that could be viewed as a potential violation, an intentional violation of their rights. Additionally, you're opening yourself up to other scrutinies, such as scrutiny under the First Amendment, for potentially promoting or disagreeing with a particular viewpoint. Once we get into viewpoint discrimination, we've got a whole other host of problems that we have to deal with. So the best thing to do during public comment is listen and say thank you when they're done and move on to the next one. As I said, an individual cannot be excluded from a meeting otherwise open to the public except for a breach of the peace actually committed at the meeting. When I mentioned the potentially interfering as being an intentional violation, we do have an opinion from the Western District of Michigan, that federal court that governs us, that actually said it was a jury question about whether or not interfering with someone during their public comment could be interpreted as an intentional violation. And intentional violations are against the individual board members themselves. And because of something we'll talk about later, the criminal aspect of intentional violations, you may be excluded even from your insurance coverage. You guys are members of the Michigan Municipal Risk Management Authority. There's a specific exclusion for criminal activity where they're going to issue a reservation right letter. If you are named with an intentional violation claim, you have the risk of potentially facing the civil penalties all on your own, or at least getting a big bill at the end of the day if they enforce that reservation of rights. So again, don't interfere with the public comment.
And interesting,
Now-
that's right here in Coldwater.
It was. Now, that doesn't mean that the public is allowed to just come up and do whatever they want during public comment, disrupt things. Again, if they breach the peace, they can be removed. But you are allowed to have what we call rules of decorum. Now, this is a case that came out a couple years ago called Eisen. It's our currently what we call our most seminal case out of the Sixth Circuit. So again, I said the Western District is the federal court that covers us. In Michigan, the next level up is the Sixth Circuit Court of Appeals before you get to the U.S. Supreme Court. Anything that comes from the Sixth Circuit is binding on us. So the Eisen versus Madison Local School District. It's funny how most of the cases that we deal with involving decorum issues, problems at boards, most of the cases are school boards. It's weird how that happens. It's either school boards or it's sleepy communities on the West Coast that are fighting over short-term rentals. We don't need to talk about that, except a little bit. But anyway, what the court said is that it's okay to have decorum rules for your board meetings, but they can't be so vague and generalized that no one can really understand what is being limited. What they struck down in the Eisen case was a very, very broad set of rules that said you can't say abusive comments, you can't have personally directed comments, and you can't have antagonistic comments. Well, one person can say something that I think is absolutely fine. The person sitting next to me might find that to be antagonistic. That is such a broad thing that those aren't rules that can explicitly be enforced. But they did allow the general observation of reasonable decorum, i.e. you can't get up and start slandering somebody. You can't get up and you're just going to go on a George Carlin 7 Deadly Words tirade. That's, a personal attack on someone. You shouldn't get up and start making racial comments that have nothing to do with the particular business of that board. So you are allowed to have some reasonable rules of decorum. We've since had additional cases where the courts have approved certain language. It's very limited. Once you start regulating the content of people's speech, you're going to inevitably face First Amendment scrutiny. So before any decorum policy is actually adopted or approved, it's going to have to go through a review process to make sure that it's consistent.
Real quick, Andrew, so as far as the time limit, so in St. Joseph County, we have 4 minutes. And most people are absolutely fine. They don't take the 4 minutes, but some go, almost filibuster. I mean, they just keep on going. Do you have like a best practices as far as what other kind of boards have done in that regard.
Well, if, I mean, one, you need to enforce that time. So you need to tell them to stop. If they continue to go, now that can be considered the breach, potentially breach of the peace, because now they are interfering with your right to proceed with your business. They were given their opportunity. They had the same time limit as everybody else. The problem you're going to face is if you allow someone to exceed the time limit, you need to allow everyone to exceed the time limit. Because if you allow one person, but then you don't allow the next person that's exceeding, now we're in viewpoint discrimination. Now we're getting into that First Amendment problem. What needs to happen is it needs to be strictly enforced as to everyone.
You need to time it. you know.
So yeah, I mean, best practice is to actually have a timer going.
And here in the past, when we had more public comment, Teresa was the keeper of the time.
To tag on to Jared's comment, we have one community member that frequently.
Hypothetically.
Hypothetical, uses foul language in the delivery of his speech. How do we handle that sort of thing?
Well, so you should adopt formal rules of decorum and make those, publish those, adopt a formal rule of decorum, and then point, out of order with regard to that language. Generally give warning before jumping to you're out of here. That was part of the issue in the case that's cited at the bottom, the Murray versus City of New Buffalo case, that one of my partners handled. The mayor may or may not have kicked anybody out of public comment that he thought was making a comment that he didn't like. So it's best to give a warning, maybe even a second warning if they continue before you cut them. But make sure though, you have adopted a decorum rule. So you have an actual rule you can point to.
Could you have that on the bottom of your agenda, so it's right there every meeting?
There'd be nothing, I mean, I'm not aware of anything that would prohibit you from doing that, but that would make it very clear for everyone that's there. But again,
Right.
the decorum rule,
Here.
though, the decorum rule can't be so vague that it's difficult to describe.
Ours you would probably say is too vague. Right on the right side in the box there.
Civil and respectful.
Civil and respectful, I don't see that there's anything necessarily wrong with that. The problem that you're going to have with civil and respectful is if you enforce it too strictly as soon as somebody gets to a line, like who's making that final determination. But that's, and we can talk about that later. Because what's nice about the Murray versus City of New Buffalo case, again, it's another Western District case, so that's the federal court that governs us. And these decorum rules apply, it's mostly a First Amendment issue, but they impact the Open Meetings Act. We have specific language that Judge Yonker has approved, and again, if one of the judges in the Western District approves it, it's unlikely any of the other ones are going to have a problem with it. So we do have specific language that we know has been approved by the courts. It's the manner of enforcement that can potentially get you in trouble. So we could spend the next 20 minutes talking about the First Amendment, but I think we should probably move on unless somebody has a specific targeted question. All right. Now we've all talked about what we need to do to be open. And here's the thing that everybody was waiting for. How do we get into closed session? Okay, so now we know that we need to do this, but there's a couple of exceptions that apply where the Open Meetings Act doesn't apply to what would otherwise be a public meeting. Like I'd already mentioned, a committee that adopts non-policy making resolutions, tributes, or memorials. So basically, a public body that doesn't actually make real decisions doesn't need to comply with the Open Meetings Act because you're not actually making a real decision. It's a non-policy making resolution tribute. As already mentioned, the social or chance gatherings or conferences not designed to avoid the statute the Meetings Act doesn't apply. Now closed sessions. These are the exceptions. These are all found in one section of the statute. Closed sessions, one thing that's important to note about closed sessions is that they are not mandatory. All of them say you may go in, You are not required to go into closed session. Again, all decisions still need to be made at the open session. That means in those limited circumstances, you can discuss and deliberate in the closed session, but you can't actually make the decision in the closed session. And inevitably there's some practice pointers. Well, then how do we ever get out of a closed session if we can't make a decision in there? Well, obviously you can take the vote to go back into open session. That's not really making a determination. But other than voting to go back into open session, you can't take any action in the closed session. Now, some of the closed sessions, as we talked about earlier, require a 2/3 roll call vote of all members that are presently sitting. So this can sometimes become a problem, like let's say for a mental health authority. Per statute, a mental health authority must have a minimum of 12 members on their board, which means in order to go into a closed session and you're a 12-member board, you need to at least have 8 members present to even take that action. And then they must all vote in favor of it. If it's 7-1, you can't go into the closed session there. Here, anytime you're going into one of the closed sessions that requires a 2/3 roll call vote, you're going to need at least 4 present and voting in favor of going into that closed session. Anytime there's a closed session, you should make a roll call vote, and the purposes of that roll call, the roll call vote itself and the purpose for going into the closed session must be included in the minutes where that vote has taken place. A separate set of minutes must be taken for each of the closed sessions. So whether you have the clerk of the board come into that meeting and take minutes, or you designate one of the board members in the closed session, someone has to take those minutes. Those minutes are not public record. Those minutes are not to be disclosed unless a judge specifically orders it. It's actually illegal to disclose those minutes. And closed session minutes may be destroyed 1 year and 1 day after the approval of the minutes of the meeting that you went into that closed session. So if we went into the closed session today, it's not 1 year and 1 day from today that we could destroy the minutes. It'd be 1 year and 1 day from the next meeting where you approve the minutes that you went into that closed session. Now, a practice pointer about approval of closed session minutes. Since closed session minutes are not a public record, people often ask, what do we do about how do we approve those closed session minutes? Because you can't just put them in the open board packet, because then you'd be disclosing it, which would be a problem. So what I always suggest doing is, while we're in that closed session, whoever's taking the minutes, just read those minutes back to everyone while you're in that closed session. The courts interpret approval of the closed session minutes. They consider it being approved when you approve that meeting that you, at the meeting where you approve the minutes to go into the closed session, without having to separately approve that. But the problem with that is then nobody ever actually got to see or hear what they were. So I always think it's easiest to just reread them, because otherwise you can get yourself into an endless cycle. Because you could go into a closed session to consider material exempt from disclosure. And if you do that, then you can review those minutes and you come out and you vote to approve the minutes from the closed session. But then you got to do that at the next meeting, and you're in this endless cycle of always doing it. So it's best, in my opinion, to just review them at that meeting before you come out. Now, purposes of closed session. This is one of the biggest ones that gets used. Section A, to consider the dismissal, suspension, disciplining, or to hear complaints or charges against personnel or a public officer. This is the personnel decision. So whether it's the annual review of someone if they ask to go into closed session, or it's to consider suspension or dismissal. This one, what's important to know about this one is you can only go into that closed session if the employee requests it. So again, all closed sessions are permissive, so you don't have to go in no matter what. This one, you may want to go in, but if the individual that you are requesting to go into closed session for says, I don't want to go into closed session, then you can't go into closed session for this purpose. You may be able to go in for a different purpose, but you can't go in to consider suspension or dismissal. And then even if they approve and say, all right, I want to go into closed session, and you vote to go into closed session, and in the middle of that closed session, that person says, okay, nope, I want to go back into open session. You have to go back into the open session. So it really is dependent on the individual that you are talking about. Here's just a really quick war story on how those things can come into play, and having good detailed minutes from the closed session can end up saving you in litigation. There was a township not far from here, not in this county, but just north of the border, that went into a closed session to discuss an suspension, dismissal, to discuss an employment matter related to the township supervisor. They went into that session, and about 20 minutes later, they come out of that session and they deliberate and vote to terminate the chief of police, not the person that they went into the closed session to discuss about. It looks very bad based just on that process. The chief of police was not there. The chief of police didn't say, please go into closed session to talk about my employment. But they came out of the closed session and fired the chief of police. That inevitably led to a lawsuit that included an Open Meetings Act violation allegation. Now, the very detailed minutes, we were ordered in that situation to disclose those minutes. The minutes were very detailed, and everybody that was in that closed session was consistent. They were talking about the township supervisor in the closed session. The chief came up as part of that discussion, and as soon as the chief's name came up, one board member said, we can't talk about the chief in this closed session. The other board members said, you're right, we have to go back into open session. And so they stopped, and the minutes, the closed session minutes reflected they stopped immediately as soon as the chief's name came up, went into the open session. And the judge said, actually, yeah, you did it the right way. As soon as you almost did the wrong thing, you did the right thing. Now, your open minutes made it look like you did the wrong thing. So maybe the open minutes could have been a little bit more detailed on that particular matter. But having those detailed minutes saved them in that situation. Here's the next section doesn't really apply to us, so I'll go fast, but it's essentially the exact same provision, but as applicable to students. Now, strategy and negotiating sessions with collective bargaining agreements if either party wants a closed session. So those you can go into a closed session for if you have a CBA you need to negotiate. To consider the purchase or lease of real property up to the time an option to purchase or lease that real property is obtained. This is one of them that requires a 2/3 vote to go into that closed session. The reason for this is if we had to talk about it in open session before we've made a determination on getting an option to purchase or lease, it's going to drive the price up because now everybody knows that you're going for it and everybody else is going to then go for it. You can go into a closed session to consult with your attorney regarding trial or settlement strategy, but only in connection with actual specific pending litigation. That's very important because it can't be threatened litigation, but litigation actually means an actual lawsuit that's already been filed in an actual court. It doesn't include an administrative proceeding that's not in a court, so that doesn't include Michigan Department of Civil Rights claims, things of that nature. It means an actual lawsuit that's been filed against the public body or an employee of the public body. And then you can only go into that closed session if discussion would negatively impact your financial position. That's an easy one to meet. You're always going to say, if we talk about the total, give away the full deck of cards in an open session, we might as well just write the big check right now. But that one, again, does require a 2/3 vote to go into the closed session. At the end of our last legislative session, there were some potential proposed amendments that could expand this to include potential litigation or administrative hearings or things of that nature. That hasn't passed, but we're hopeful that those things eventually will make their way through. So maybe next time we have this presentation, they're a little bit more expansive on that. But there is a workaround we'll talk about. You can go into a closed session to consider the contents of an application only if that candidate requests that their material be private. However, you cannot do interviews in closed session. I'm not sure if you guys are aware of this, but there's a statute for county government that if an elected official leaves office for some reason, dies, whatever, prior to the expiration of their term, there's a statutory committee that's established to fill that void. That statutory committee consists of the chief probate judge, the prosecutor, and the clerk. Well, last I checked, judge has to be a lawyer, the prosecutor has to be a lawyer, and then you've got a clerk. They get sued quite a bit because somehow those three can't follow the Open Meetings Act, because back in 1981, the Michigan Court of Appeals held that that committee is a public body and needs to comply with the Open Meetings Act. And I wish I didn't have to say that I've had to defend those people from conducting when they've decided we're going to have our interviews in private, we're going to do private votes. You got to be kidding. We've got 2 attorneys on this board. I mean, one of which has the responsibility of enforcing the criminal provisions of the very act that you're violating. Nice. Good job.
Actually, two, they both do, because the
The
one.
probate judge generally gets to deal with matters not related to the criminal and civil aspects, but the prosecutor. Anyway. Look who doesn't want to go or have their discussions in open session. Partisan caucuses of the state legislature. Yeah, we can have ours in secret. Oh, and they don't require a 2/3 vote, because what are the chances we could get 2/3 of them together to have their secret meeting anyway? This is the workaround on the threatened litigation or other legal matters. To consider material exempt from discussion or disclosure by state or federal statute. This covers materials that could be prevented from disclosure under FOIA. FOIA has a specific exemption for attorney-client privileged information. So that would be a written attorney-client memo. So if you have a legal opinion from your attorney, you can go into a closed session, but that discussion in that closed session needs to be limited to the actual legal advice contained in that written memo. It's not an excuse to now go into closed session and talk about anything and everything you want to with your attorney. You still need to comply with the law. It also includes other things such as HIPAA and what other various other statutes prevent the disclosure of information in public session. Minutes. Every meeting needs to have your minutes. The minutes at a minimum need to show the date, time, place, members present, members absent, all decisions made at the meeting, and all the purposes for going into any closed session, along with all roll call votes that were taken. That's the minimum requirement under the Open Meetings Act. Your own individual policies and procedures may require more. You can have more detail in it if you want. There's a fine line between too detailed and not enough detail, but this is the minimum that's required under the Open Meetings Act. You must make any corrections at your next meeting, after which those meetings refer. And then you must make your corrected minutes available at or before the next meeting after you've corrected them. Now, this is a relatively recent change. You're correct. If you are going to make corrections to the minutes, when you post those, you need to show the original and what the corrections were made. So just keep that in mind. If you're not simply approving, but you need to make a correction, when those corrections are made, we need to have both versions available. Minutes, including closed session minutes, are public records open to public inspection. You must make them available. You must make copies available. And you can charge if you want to, but charging for copies of minutes is very limited under FOIA. Plus, if you post them on your website, you can always just refer people to the website where they can get them for free. Only if they demand to have a paper copy, really can you charge them for it. Your proposed minutes must be available within 8 business days after your meeting, and the approved minutes must be available within 5 days after their approval. The public body shall not include any personally identifiable information that, if released, would prevent you from complying with Family Educational Rights Act 74. It's a specific provision that really only applies to school boards and public higher education institutions. As mentioned, the closed session, we've already talked about the minutes for the closed session, so we don't need to talk about that. There was a provision that was added a couple years ago about state level rulemaking, licensing, commissioning panels that required all of their meetings to actually be recorded. Thus far, those haven't come down as required on the local level yet. Now, we can record them, that's fine, but it's not a requirement under the Open Meetings Act as of now. All decisions made at an open meeting are presumed to be valid, but people can challenge them if they want to. So we're going to talk about invalidating. There's 3 different types of lawsuits that can be filed. One is to challenge a decision that was made to invalidate your decision. So in order for it to be invalidated, or rather, in order for you to win that case, your decision needed to be made at a public place, open to the public, allowed all persons to attend. You had it properly noticed. You made that decision at that open meeting. You deliberated toward it at that open meeting. And if you did that, you're going to be fined. If you didn't do those things, it could be invalidated. If you failed to give proper notice, you had your meeting without notice, it could be invalidated. Invalidation is not one of the most common types of actions that we see. Generally, the courts say that your non-compliance, let's say if you failed to provide the phone number on the notice, the courts have held minor problems with technical requirements like that. Don't really impair the rights of the public. So they're unlikely to invalidate in those types of situations. So for the most part, the invalidation claims, we don't see those very often. In most cases, they have to file that invalidation claim within 60 days after the minutes are issued. Unless the invalidation has to do with the issuance of a contract or the acceptance of bids, in which case they only have 30 days to bring that action. So those are relatively short windows when we're talking about civil litigation. So again, invalidation is an unlikely thing that we see. If they're going to seek invalidation, they have to file it in one of the counties in which we operate. So for us being a 3-county health agency, they can file it in any of our 3 counties. Even if the decision is made here at this board meeting, it can be done in any, because we do business and operate over all 3. But one of the other good things about the invalidation claims is we can reenact. If somebody does sue and claim that we've done something wrong, we can immediately reenact that action, and reenacting it cannot be used against us to prove that the original decision was wrong. I mean, it's not going to look good, but it's not proof that you screwed up the first time. But the one thing about the reenactment is the decision only is effective from the date of reenactment, unless you get the court to say that the original decision was okay. Now, the lawsuits to compel compliance. This used to be the one that we saw most frequently in defending these cases. This is where someone is filing for an injunction because they are claiming that you do not comply with the Open Meetings Act. They are filing an action to compel your compliance. Injunctive relief must be in the circuit court. Again, as a 3-county body, it can be any of our 3 counties. If the person commences that action, they're not required to post bond. A lot of times when you're in a civil case and you're requesting preliminary injunctions or temporary restraining orders, you have to post some level of security. They're not required to do that in these types of actions. They can file what's called a mandamus action, which is essentially the same thing, but it goes straight to the Court of Appeals. If a public body is not complying with the act, and the person is able to get an injunction, i.e. they succeed in obtaining relief, they get their attorney's fees for filing that action. Now, that phrase, succeeds in obtaining relief in the action, used to be the reason that we saw these lawsuits so often. Because what would often happen is someone could find a situation where you had a violation the Open Meetings Act. Maybe you didn't deliberate in public, or you improperly went into a closed session. They would file the lawsuit under this section to compel your compliance, even though it was a one-time thing and there was no chance that they were ever going to actually get an injunction. But then they would ask the judge to issue a declaratory ruling that said you did violate. And when they would do that, the court would say, okay, I'm not going to grant you the injunction, but I will declare that there was a violation. And then I'll say, because I declared there was a violation, you have succeeded in obtaining relief in this action, and now you get your attorney's fees. It was a nice little cottage industry for a while. Eventually, though, thankfully, our Supreme Court stepped in. This was going on for 20 plus years. It was in the mid 90s when the decision came down that declaratory relief was success. But about 7 or 8 years ago, our Supreme Court finally stepped in and said, no, this statutory provision says you need to get an injunction. If you can't get the injunction, then you're not. Just having a declaration that one time in the past they violated isn't going to be good enough. And if you don't have that provision for actual attorney's fees, it really dries up the incentive for an attorney to take a case like that, because they're not going to get paid at the end of the day. It doesn't prevent your local gadflies that don't have attorneys that we're going to do this one way or the other. We have a lot of those around the state, but it's the ones where you're facing the attorney and the potential big bill. This was a big impact. There's a couple of attorneys that made a lot of money just searching for old violations and filing these lawsuits for a long time. But that dried up, thankfully. So we don't need to deal with those so much, but some of these attorneys have figured out a workaround to that division. So now we're going to talk about the not so fun part, because we've had so much fun. The intentional violation claims. Intentional violations have two different provisions. The criminal provision: a public official who intentionally violates this act is guilty of a misdemeanor, punishable by a fine. If you are convicted a second time, you can go to jail for a year if you've intentionally violated. Not only are there the criminal provisions, and trust me, the Michigan State Police do investigate intentional OMA violations fairly regularly. They don't get prosecuted very often, but they will investigate them if a complaint is made. But you also face civil penalties. A public official who intentionally violates this shall be personally liable in civil action for up to $500, plus actual costs and attorney's fees. So this is the way that everybody that used to just file under the injunctive relief portion is now making claims against the board members individually if they can find a violation. They say, well, you intentionally violated, and so if we can establish a violation, then they're back to the potential of getting their attorney's fees. Which gets us to a little bit of an issue. How do we defend a case like that? The Michigan Court of Appeals in People versus Whitney said intentionally violating the OMA is a specific intent crime. Quote, an offender must have a subjective desire to violate the OMA or knowledge that the offender is committing an act violative of the OMA. Which means we either need to say there was no violation, but if there was a violation, I was too dumb to know that it was a violation. I didn't intend to know that it was I just didn't know I was supposed to do that. Which is not a great look. Let's say you're that committee that has to reappoint the treasurer. Not a good look for the judge and the prosecutor. I guess I didn't even know that I wasn't supposed to interview everyone in closed session and have a secret vote for who the next treasurer should be. Not that we've dealt with that. One thing about those penalties that's somewhat good for those intentional violations is that you can't have more than one action for any one meeting. So, you could have 30, like if you're going to violate, just get them all out in one meeting, because you're only going to face the penalty and the violations one time. Really don't do it at all. But another thing is it's 180-day statute of limitations. for a claim for an intentional violation, which is another thing that back on the injunctive side, there really is no statute of limitations for that type of claim because they're claiming that they need to force you to comply. There is no statute of limitations on that, because they're alleging that you haven't complied in the past, but they're alleging future action. So they don't have a statute. This is good. The intentional violations, 180 days, 6 months. It's a relatively long statute of limitations for something like this. But again, if you're going to violate, get them all out at once. All right. Now that we're done with the Open Meetings Act, I'm open to any questions on anything with the Open Meetings Act that we haven't touched on that you want to address before we just move on to some of these other provisions?
I just have one question about, I'm on a board that we have
Hypothetical.
hypothetical. Yeah, but we have 9 positions there, but we only have 7 people. Does that fall under, you need to go with the 5 or the 4 to have quorum?
Well, so I actually just had this come up with another one of these mental health organizations that have those really big boards, similar to this. This is my take in dealing with that hypothetical. If those are vacant, unfilled positions, the statute says appointed and serving. So you actually have to already be on the board in order to count towards it. So if it's a vacant position that hasn't been filled yet, my advice is that you follow that 7 is the total,
Okay.
hypothetically, that are appointed and serving at that point in time. So a situation that I had come up was a 6 county board with a 16-member board. There were only 15 that were appointed and serving. Someone had been appointed, but their term didn't take effect until April 1st. So at the time that we were at the meeting, there was only 15 appointed and serving. So we only needed 10 as opposed to 11. Because you always have to round up on 2/3. You don't get to round up. So I would check with the general counsel of whoever that board is just to get confirmation. But just my general advice would be you actually have to have the appointed members because it's those appointed and served.
I had a question. Hypothetically, is there any activity around the legislature changing some of this stuff around the technology changes or anything like that?
Well,
Do you have any-
As I mentioned earlier, there's the potential of them adding the requirements for the recording. But as far as like the technology thing, like, are you talking about having electronic attendance again?
or phones
Oh.
out or whatever during meetings or?
Well, I doubt that the statutes are going to ever make a specific implication on that. You can't even have those things out and available, because they would have to change the statute every couple of years. Because I don't know what the new technology is going to be, and
Right, but they haven't changed it in what, 45 years? or
well, they
whatever.
changed it in saying you can't have remote attendance anymore. They've
Sure.
changed it to require, at least at the state level, that you have to have recording of things. So the legislature moves very, very slowly. But I don't anticipate, or at least I haven't seen anything on that side. It's been more changes with regard to expanding certain exceptions to going into closed session and things of that nature. I mean, it's really practical application on how you guys are going to do things. So I know a couple city councils that I do work with. One of the things that they have is at their council table, everybody has a touchscreen that comes up, but that touchscreen is limited only to intranet and it only has access to the board packet that's publicly available. So they're not even allowed to go onto the internet with that. The only way that they would do that is if they pull out their personal device. But once you pull out your personal device, now you're getting yourself subject to the scrutiny of everybody that's in the public that gets to watch you and go, oh, wait, you were on your personal phone during that meeting. Now maybe we get that newspaper reporter that's going to call for that FOIA request for all texts and messages that were sent during that time frame. And then maybe we're back in the Ann Arbor situation. So best practice is to just don't use your personal devices. Keep them, on silent or turned away. I understand that there can be emergencies where you might need to take a call or something, but the best practice is to not be on your devices during those things, unless the device has only got your board packet, things like that. Conflicts of interest. Anything else? Okay. So conflicts of interest. What is a conflict of interest? Just generally in the realm of municipal servitude. It's generally a situation where there's a conflict between an individual's self-interest and his or her public duties or obligations. There are a number of statutes I'm going to just briefly go through just to give us an idea of some of our statutory bases for where these conflict of interest can come up. We have Contracts with Public Servants and Public Entities Act, MCL 15.231. This is a statute that prohibits a public servant, which a member of the Board of Health probably qualifies as, from directly or indirectly soliciting a contract where the public servant is a party to the contract, a partner, member, or employee of the party to the contract, a stockholder of more than 1% or $25,000 of publicly traded of that contract, or the beneficiary of a trust that is a party to that contract. So basically, don't be on a board and ask the board to contract with you or something you own a substantial portion of. Another one of the statutes that touches on this is the Incompatible Public Offices Act. This is a statute that holds a public employee or public officer, which again, by definition, would include the members of the Board of Health, may or may not hold two or more incompatible offices at the same time with various exceptions. So this is a situation where the conflict of interest is between the two public bodies that you're serving. But one thing to note is our Court of Appeals has held that a potential for a future conflict of interest between two public offices is not sufficient to create an actual violation of the statute. In the case Macomb County Prosecutor versus Murphy, they found that the delinquent property tax coordinator for the county and township trustee were not incompatible. It could in the future become incompatible if the county and the township negotiated a contract in which the county would take over the responsibility of collecting delinquent property taxes for the township. But up until the conflict is actual, the Incompatible Offices Act doesn't apply. Standards of Conduct for Public Officers and Employees Act, MCL 15.341. I don't know if you're paying attention, but everything under the MCL starts with 15. That tends to be all the stuff that's going to generally govern public bodies. That's where the Whistleblower Protection Act is. That's where FOIA is. That's where the Open Meetings Act is. That's where these statutes are. This statute prohibits public officers and employees from using confidential information for personal gain, engaging in business by reason of their public employment or office, soliciting or accepting gifts, which tend to influence official duties, i.e., hey, I'll pay for that trip to Florida if, I get that contract that you guys are bidding out. Using public personnel for personal gain, i.e., requiring your staff to help support you in your campaign for re-election, things like that. Those are problematic. This statute has some provisions that relate to contracts. But there are exceptions for contracts, and this is all really fine print. I'll get this over to, or Teresa has this, so she can forward this on to you. But the general prohibition doesn't apply if you can meet certain exceptions, such as one of the exceptions is if there was a quorum necessary for the action that would have taken the action without you. The public officer was not paid for working more than 25 hours per week, and the public officer promptly disclosed their role and potential conflict before that decision was made. Or if it's towards a contract all of the conditions in the previous section were met. You did not directly benefit from the contract in an amount of $250 or less than 5% of the public cost of the contract. And you file a sworn affidavit containing all of the information that you didn't receive those funds. And that's made public. So you got to go through a ton of steps if it turns out there was a conflict that can potentially make those contracts okay. But what's really significant is if you don't do any of those things and you do the self-dealing, there are pretty substantial civil penalties, just like there are in the Open Meetings Act. You can have civil violation against that individual for up to $500. And if someone sues you and they're successful, they get the recovery of their attorney's fees on top of any actual damages and the $500 fine that they can show. So now, along with all of those statutory provisions that just generally prohibit conflict of interest and cover conflicts of interest, we, as the policy board for the Area Agency on Aging 3C, also have a specific conflict of interest form and agreement that we all have to engage in. I'm sure you're familiar with it. Posted a copy of it. That just further outlines our obligations that are pretty consistent with the obligations under all those statutes. You got to disclose if there's a conflict of interest or a potential conflict of interest, you've got to disclose it once it becomes apparent. What do you do in situations where there's a potential conflict of interest? Best practice is always be open, upfront, and disclose those things. If it's only a potential or a possible conflict of interest, but it's not an actual one, make sure you've disclosed it. Allow the remainder of the board to make a decision on your participation or voluntarily recuse yourself in the event that it's potential. If it's an actual, recuse yourself and do not participate in that decision. And if it's a decision that involves the reward of a contract, make sure you follow through on all those provisions 3 slides ago by not participating, making sure the decision's made without you, swearing to not receiving any benefit from it, etc. Because if you don't, there's the potential for the significant violations. So without anything else, open it up to just any general questions while I'm still here on these topics. Otherwise, I thank you very much for your time.
Question, I guess, on the conflict. Excuse me. You mentioned that we do serve, as commissioners, we serve on multiple boards. And just for example, I'm on the Branch County COA board, which does get awarded contracts from the AAA. And here I am today. Do you see potential conflict there?
So what we'd have to, for the Incompatible Offices Act, you'd have to look at what's goes on. I just wanted to touch on these things to bring them up. Okay. There are so many exceptions built into the Incompatible Offices Act that I can't say one way or the other right now. But we also have the provision of is there actual self-dealing going on? And
sure.
So
I get that.
We're not really probably talking about the conflict of interest. We're really more or less talking about the Incompatible Offices provision. And without, doing a deep dive on that right now, I can't say one way or the other than my initial thought is probably not.
Okay. I'm sure it's not just me that has.
Yes, a lot of people serve on multiple boards, but the thing is, when we have a health agency like this, you inevitably have to have the county commissioner serving on your board because that's the way that we're established. Same thing with a mental health organization or so many other organizations that require membership of different people, which is why the statutory portions on the exceptions almost swallows the rule to some extent. There are so many things that need to be looked at, but okay, more than likely it's not. All right. More than likely.
Anybody else? Any questions? Good.
All right. Well,
Thanks
thank
so
you very much.
Appreciate it.
Sir.
Okay, moving along on our agenda here, we're up to public comment. There's anybody in the room that.
Okay.
Are you ready? Just give us your name and
Yeah, my name is James Bronte. Let me get my camera over here.
I'll let you take a break for a few minutes if you want.
We're good.
Yes, my name is James Bronte. I actually, some of you might recognize my name. I actually ran for office here in the 5th District of Michigan for the Green Party. And one of the reasons that I ran is what I'm going to talk with you briefly here for 3 minutes about is our health system. And the big dog in our health system, oh, by the way, you've just been instructed on how to handle public comment. I guess I'm your first test case. So anyways, 2 years ago, I was diagnosed with prostate cancer. Okay, I'm 74 years old, but I'm pretty damn healthy 74 years old because I compete at the Arnold's in powerlifting. And I have state records in powerlifting. But that doesn't matter from what I'm talking about. I was diagnosed with prostate cancer in Niles, where I went to the urology there. They examined me the way they do, up to the point of a biopsy, and gave me a Gleason score of 7. Well, I did my research, a lot of research. And what does it take to do research these days? You get on Google and you go prostate cancer, and you start watching videos on YouTube. I probably watched 100 videos. So what I ended up learning is that one of the most effective treatments against cancer is fasting. So what did I start doing? Fasting. It cut into my lifting, but it works. And that's just the beginning. The book I finally came across is this book called How to Starve Cancer, Jane McCullough, one of the smartest ladies in the world in solving cancer. She's out of England, and because when you fast, this is my simple way of looking at it, when you fast, your body is very efficient at going after your stored fat. Cancer cells can't do that. But you know what the problem is? Your doctors here won't tell you about that. They got radiation for you. They got chemo for you. They'll take out your prostate. And I know a guy who still got cancer after his prostate was just removed. So this is a problem. We've got doctors, and my own personal physician, who I just had a 45-minute discussion with, just in January. He said he won't be telling people about it because it's not covered by, it's not first approved by the FDA, and so it's not covered by your insurance. And so what I'm doing is it costs a tiny fraction of what people pay for when they get your radiation or chemo, but still, because it's not covered by insurance. Is that my time?
It is.
The other thing was CanC, which takes care of cataracts.
All right. Thanks for your comments.
Thank you.
Appreciate it.
Okay, I'd love to hear what you people think can be done about this kind of stuff. That's all.
Is there anybody else that would like to address the board? No? All right. We'll move along here to the health officer's report. Rebecca.
Good morning.
Good morning.
So the county health rankings are out, and they are provided today in the report. They start on page 8. This will be, we've been notified the last year of this information being shared by the University of Wisconsin Population Health, because the Robert Wood Johnson Foundation, who's been funding this work, is going to be changing direction with how they do their funding. So what the areas of concern include this year, years of life loss before 75, physical inactivity, excessive drinking, and injury deaths. We've seen some improvements in sexually transmitted infections in Branch and St. Joseph County, child poverty, and teen births. So it is a snapshot of information. It takes a lot of other pieces like the BRFS and other survey data and uses that to come up with our county health ranking information. And if you'd like to take a closer look at that and have further conversations, we'd be happy to do that. On Wednesday last week, we participated in the statewide tornado drill. We do that in all of our offices so that we are prepared in case of severe weather. So that went well. We are also working in emergency preparedness to update our memos of understanding with the entities that have agreed in the past to utilize their space if we need to stand up a mass vaccination clinic, to script medications in the event of an emergency. So just an update there on staffing. Respiratory season, we are starting to see a decline in influenza. Thank goodness, we're at the tippy top of the high and it's starting to come down. Just a few public health concerns I wanted to point out today. We're still waiting for the blood universal testing rules to be published by JCAR. We continue to be concerned with the highly pathogenic avian influenza or bird flu. So still seeing some flocks affected with that. We are currently reviewing our measles response plan for the agency, as we now have a confirmed case of measles in Michigan for 2025, and one case of measles in Oakland County resulted in 56 contacts. So you can see how very quickly measles can quickly spread and create a lot of work in public health and agencies to try to prevent further spread. And what happens in those cases is those 56 individuals will be followed by Oakland County for a period of time to ensure that they don't develop symptoms. So it's a time-intensive process. There is a safe and effective vaccine to prevent measles, and we continue to encourage families, individuals to investigate and consider those actions. Fluoride in drinking water, I did provide a joint statement that came out from Eagle and MDHHS on this topic. Just came out last week, and I thought it was important to share. Fluoride has been added to drinking water supplies for a number of years, and it's been proven to grow strong, healthy teeth in children. Pediatricians for children that are not on a municipal water supply with fluoride will often prescribe fluoride tablets instead. So it is an important public health action to prevent dental caries. We had the boot truck here at this building this week working on the HVAC. The bids are being collected for counters and sinks in this building right now. Our Hillsdale office, the FAB project that you approved last month has been completed, so that is all set. And the contractor that worked with us on the Three Rivers exterior visited that location to help us develop a specification sheet for the work to be done there. He did find some issues. There are two exterior doors. I'm trying to think what direction they're in.
East and west.
Thank you. East and west doors that were not installed correctly. So there should have been a threshold that went and extended over the brick, and that is not what happened. So they butted up to the brick and they caulked between the brick and the threshold. So what's happened over the course of 30+ years?
The caulk falls out, the
The-
water goes in.
Yeah, so there's been water infiltrating down behind the brick in that area. So he pointed that out. He pointed out that there's been significant hail damage to the roof of that building. There are roof shingles that are just sitting up there and aren't even attached. They're just on the roof. So there were several issues I outlined up here for you. We are going to need to take action, obviously, and he's going to be putting that specification sheet together so that we can take some bids. And we don't know what we're gonna find when we dig into that, where those doors are, as far as how much water damage there might be. So we will wait and find out. Nothing for Sturgis at this time, and in Three Rivers, we have today for your review and consideration, a bid for painting of the interior of that building that the finance committee reviewed. I have contacted references for this company. They were very positive, reviews from all the companies that I contacted. I did ask the company if awarded, when did they start, and they said April. And so I'm also working currently to collect carpet bids for carpet replacement in that building as well. The funding to pay for these projects would come out of the infrastructure grant. That's all I have for you today.
A question regarding the health rankings. So it sounds like it's costly for them to produce those. That's why they're stopping. Yeah.
You know, I'm not exactly sure that they've given a reason. They've just indicated that they are not going to fund it further. This information is available in other sources. It's just not all pulled together into one. And this has always allowed us the opportunity to look at where we stand in relationship to other states and other counties.
Yeah, that's what I was kind of going to get at a little bit. So I do understand we've talked about this before. It's tough to move the needle on some of that stuff.
Yes.
But it is a useful document, I think. Is there, I mean, initially, do you have thoughts on reproducing it in a different way or coming up with our own report that we're monitoring these metrics?
You know, there's talk about this. I think it would be pretty time consuming to individually have staff go out and try to pull this all in
Mhm.
and produce something similar. But there is certainly talk amongst other local health departments in the state about again, at the state level, about, how do we continue to look at this way and
Sure. Okay,
we
so more to
can
come
consider
maybe
it.
than that.
Yeah.
All right. Good. Okay, any other questions?
In regard to the roof on the Hillside building, I'm guessing that's the original roof.
No, it was replaced.
It was.
Yes. I don't remember the year, Commissioner Lander, but that is the second roof for that building.
It's going to be out.
Yeah, metal roofs only, yeah. Dr. Lucarello, had an unexpected change and she did video her report today for you,
All right,
so.
sounds good.
Well, is that it, Chris?
It gave me an error message. I may be able to still play it so you can hear the video or hear it. But if the televisions are not cooperating with this.
So she provides, on page 19, her regular, report of activities that she's been involved in for the past month. And then her, taped or recorded report is going further into the topic of measles. And I would say if we can't show it, we just go ahead and skip it for today, unless we wish to hear it.
I agree with that.
They got it up there.
Yeah, but it's not on the TVs. It's up to you. It's up to you, however you wish.
I would say we skip it, but I don't know if anybody
I
else
mean, you
has
can,
thoughts.
Chris, can you just email it out to all the
Good morning. Sorry I can't be there in person for this board meeting.
We can listen to it.
My report is in your packet. Some things that are a bit unusual were that we had these meetings at St. County, 2 latent tuberculosis patients and 1 in Branch County with a latent tuberculosis patient. While all of those patients are getting treated and have been really important. We also are preparing to attend the Capitol Day in Lansing on April 9th and with me with Chris from the so continued conversations with area providers on all sorts of things, including the respiratory illnesses that we have seen all coming down, and a little bit on measles, which is also my educational section for this month. So we've all heard about measles repeatedly on the radio and the news. It has caused some fear and alarm, which by all accounts, we should all be very educated on the measles and how to prevent the measles. So in a way, it's very at the forefront, but obviously we don't want people getting sick in town. So we're going to talk a little bit about measles, or rubiola, as some of us know it. And it is a highly contagious viral illness with lots of complications, and doses of the measles, mumps, rubella vaccine can prevent the infection. So, and that is our best protection with measles, is to be vaccinated, to be surrounded by people for a vaccine. Measles was declared eliminated in the year 2000 in the United States, and that means that there was no transmission for at least 12 months. So we really need to think about that this was an eradicated disease. We didn't have it in the US, weren't worried about it vaccinating and moving forward. So 50% of individuals without immunity being exposed to measles will become ill from the virus. And we lived in the air for 2 hours. Think about that in a daycare setting or a school setting. So I can have measles, I could cough, I could release the virus into the air, I could leave the area, and then other people are exposed to it. And the symptoms begin about 7 to 14 days after the infection. So we've all heard of those. Water in the eyes, red eyes, and then we start to develop what we call complex spots, these white spots, about 2 to 3 days after our original symptoms, and then we get the traditional measles red. It begins as flat red spot in the hairline, and then it progresses to the neck and the trunk and the arms and the legs and the feet, and we can get a spot on top of that rash as well. And when the rash occurs, we can get a fever up to 104. So pretty sick, pretty significant. Complications include ear infections. So 1 out of every 10 children with measles will have an ear infection. Diarrhea will occur in 1 out of 10 people as well. In unvaccinated people, 1 out of 20 will get pneumonia, and that is the most common cause of death. 1 child out of every 1,000 with measles will develop encephalitis, and that's some swelling in the brain. This can lead to convulsions, it can lead to deafness, and importantly, can also lead to nearly 1 in 3 of every 1,000 children who get measles will die from a respiratory or neurologic complication. If you're pregnant and haven't had the MMR vaccine, measles can cause premature birth and low birth weight. And long-term complications for measles include something called acute sclerosing panencephalitis, which is a fatal disease of the central nervous system and can develop even 7 to 10 years after measles. So even though you're fully recovered, you're still at risk. So to end, I just wanted to present some facts. So in 1963, the first measles vaccine became available. In 68, the vaccine was improved. And in 1971, we combined the measles, mumps, rubella vaccine. In 1989, there were very low vaccine rates, which led to increase in measles outbreaks. And in 2000, that's when we saw measles was eliminated from the United States. That means, again, no cases for So that was after the vaccine went up from the 19% increase. In 2023, we had 47 cases of measles in the United States. In 2024, we had 285 cases, and 69% of those were outbreak related. So that means there are 3 or more people all exposed together, all related. In 2025, so far, as of March 20th, there have been 378 cases in the United States, and 90% so the message for this report and all of the health department's outreach programs is to get vaccinated. That's your best protection. Right now, that's really the only protection we have for measles. So very, very important to talk to your children, your grandchildren, your neighbors, your friends, people you associate with about getting vaccinated. And thank you. If you have any questions, feel free to call me. And you can always reach me by cell phone if needed or email. I would like to thank Chris for helping me to record this message today. Thank you.
Okay. We're up to department reports, area agency on aging.
Good morning. Bear with me. I'm battling and in the middle of battling my respiratory illness. I do have a lozenge in, so if you, again, please pardon the interruption. So we've had a busy month. We're definitely still seeing a lot of cases with our services to victims of elder abuse staff and program. They're also continuing and sort of along the same line of directly serving victims. They're working on presentations and partner education to bolster awareness and prevention of further abuse, neglect, or exploitation. The most recent continuing resolution, as you're all probably very aware of, that was enacted on March 14th. It funds the government through the end of this fiscal year. So the Older Americans Act programs, which we utilize to fund local direct services, the outreach program for low-income Medicare beneficiaries called MIPA, and then the state health insurance program were level funded at last year's funding levels. We are in a sort of a wait and see period right now because the federal notice of award has to go to the states, and the ACLS Bureau has not announced that they've received that award yet. So once they get it, they have to put it through their paces and then distribute it to all the area agencies in the form of a statement of grant award to us. So we're still sort of awaiting that. And then once we do receive that, we can move forward with conversations, analysis, discussion, and then some action with the finance committee and the full board for budget amendments. I would love to introduce you to our 2 newest staff members in our division. Cindy Headley is our part-time outreach specialist. She came on board to provide information assistance, a lot of sort of be the front face of the agency, and also work in the No Wrong Door project to offer options counseling and health insurance counseling. So Cindy has a great background, a lot of work in the schools, but is very aware and has been a public health employee in the past. So she came back to us, and we're excited to have her in the area agency division. Alexandra Curtis is a nurse. She goes by Alex and is working in the community living program as a care consultant. She is very new to the Aging Network as she's been in the hospital field for many years, for a couple of years now. And she definitely has adjusted well to home visits. Her very first week on the job, they had a really very difficult home situation that they were working with a new participant. And so she's learning all those ropes very well, fully immersed. So we're glad to have you both, and welcome to the Board of Health meetings. We do have one more full-time outreach specialist position that's posted, and we're in process with that. That brings me to my final sort of meh. It's kind of a meh, as they say among the younger kids these days. It's a meh update. We're definitely in a transition time. So just like the federal notice of award and trickling down into a statement of grant award to the locals. We're in that phase with the Snow Round Door grant. Our lead agency in this project has not gotten a fully and executed a contract yet. So we are still sort of in this wait and see period. Although everything is propulsing and propelling forward. Cindy attended a 4-day training 2 weeks ago. They provided this to over 60 individuals. So projects and programs and local partnerships are doing this work. We just don't have a contract in place. So it's really making a lot of people feel very unsettled. But we want to assume the best and, obviously make our voices heard with our state bureau folks. But to date, we have no updates related to that. So we are moving forward cautiously. We are staying in contact with our providers as we near the end of the current state health insurance program counseling period. March 31 is the end of that contract. I don't have anything to propel it forward other than please stay tuned, and we will monitor it closely as we do daily. We share updates. The state is sharing updates with us, like programmatically. Does not doesn't have the backbone that it needs to have. So, just wanted the board to be aware of that. And then my final update is related to the planning document for next year, the 2026 annual implementation plan. Chris and I just worked on and finalized a press release to announce the public hearing that will be held in Three Rivers on April 28th for next year's planning document. They're asking us to base the budget on 2024 levels because that's all we have as of right now. So we're not proposing anything monumental, substantive, earth-shattering. So it would be a very low-key plan. And we will certainly be sending that announcement to our Board of Health in its final draft format, probably yet today. So
That's your hearing in Three Rivers. When will your hearing be in Coldwater?
we're only required to hold one. Last year we held it here, so we're going to hold it over in Three Rivers this year
And when will that document come to the Program Policy and Appeals Committee?
at the May meeting. Same with finance.
All right. Other questions?
It will be available virtually if you wanted to join the public hearing virtually. We host it weekly. Just as a side note.
All right. Thanks, Laura. We'll move on to personal health and disease prevention.
Just a few updates, and I'll bet you touched on the influenza. Of course, are looking better. We're still high risk, but not that magenta purple type color. But as of yesterday, nationally there have been 151 influenza related pediatric deaths, and then 6 for Michigan. And one of those children did reside in our jurisdiction, so that was concerning. The state did say that doses of influenza vaccine did increase by 5,000 in the last 5 weeks. So maybe advertising and push for that making a difference. I did for each county I ran a recall where children 6 months to 8 years due for their second dose. And they all, each patient, we're currently working on that. They're calling the parents, trying to get them on the books to see if they're interested in that second dose. So kind of working on that. H5N1, it's like states still receiving sick bird calls on a daily basis. They said they emphasize biosecurity is the main defense. So I did include a link to some information and checklists on that. I also included phone numbers to report some sick birds. And I did include the eyes in the field, report natural resource violations of that link. Dr. Lucarello kind of gave you her data on measles. I'll jump over that. The state is kind of watching one situation. Ontario has been experiencing an outbreak in October 2024. And as of March 13th, 372 cases have been identified, and that's an increase of 195 cases since February 27th. So we have been sharing all alerts and information on measles with our partners. I have been in contact with the infection preventionists at each hospital, each agency in our jurisdiction. I've had to make sure they have all the supplies they need and they're ready for when and if we get that call. RSV and COVID activity is decreasing, as well as pneumonia. And they're saying that it looks like it's kind of shifted to the older individuals instead of the younger group for pneumonia. I did update the list for TB and LTBI cases, just so you guys kind of know what we're dealing with. It's very time consuming for our nurses, so I just like to keep that updated for you. Our STI HIV coordinator did attend a virtual conference on HIV and AIDS. Very educational. They got to listen to some people's personal stories and some presentations on different topics, which is good timing because our numbers are kind of going through an uptick right now on STI and HIV cases. So we're also gearing up for the testing day, which is June 27th, making sure we have supplies for that. We're going to advertise. Walk-ins are welcome as well. Staff updates. We did actually hire a new breastfeeding hold on, she'll start. I have received a couple resumes for mobile units. We'll be looking at setting those for some interviews soon. As far as WIC, we did apply for some funding for the Parent Pit Stop Initiative. This just kind of helps us support services and get the community engaged. We requested $1,000 in funding, and if we are approved for that, we plan on using that to purchase items for the community baby showers that are coming up. For children's mental health care, they've been working on kind of enhancing their outreach as far as to make sure the community knows who qualifies in this program and getting the word out that way. For hearing and vision, they are going to come to a situation where families are being referred for treatment, but nobody wants to participate with medication. So that's something they've really been trying to deal with. They're working with Dr. Lucarello for some ideas as well. That's very frustrating for parents and the staff. So for the co-op program, our hygienist is busy trying to, she wants to make as many kindergarten roundups as possible, but they like to schedule on the same day. She's kind of focusing on schools that have the most kindergartners. So right now she's scheduled for 7 but that program's keeping her busy. That's all I have.
Questions? I just have one. So when do, I think there's probably a report released on the effectiveness of the flu vaccine, right? Annually.
Yeah, I'm not sure if that is out yet.
I'm sure not because the flu season's
Right.
not over yet. But do you know when that typically comes out?
I don't know.
Okay. All right.
I have one you mentioned in there, looking for a nurse for the mobile unit. I noticed on my way here this morning, the mobile unit is sitting at the corner of Johnson Road and Marshall Street. What's going on with it?
Well, it had some exterior damage to the back corner. We have no idea how, when it happened. We just have, our EPC does routine evaluations of that every month. Goes out and, does a good look over, and he found it one inspection. So we sent it up there for body work. And I looked at it as well this morning. Looked to me like I think it's done. I'm guessing we'll probably be asked to pick it up. So that is why it's there. It is fine.
Insurance.
Yeah.
We did file an insurance.
And it was really high. It was, I stand 5'8", as far as I couldn't reach it. But it was damage to the, it's not metal up there, it's
Fiberglass. Hit a branch or something?
I can't explain that. I was like, did a truck with a ladder back into it? Did a branch, but yeah, we do not know. We just know that it was damaged.
All right. On to health, education, and promotion.
Good morning.
Good morning.
So you have my report, and you will see that the Office of Highway Safety Planning grant is coming along well. Wanted to just real quickly, if this is going to cooperate with me, show you the door art. And those billboards are up in all 3 counties across the jurisdiction. We have radio spots that you may be hearing in your areas. And we will be seeing video production on gas station pumps coming soon across the 3 counties around going slow and being safe and respectful of each other. So very excited about that. It's been fun to watch everything come to light. We have completed our 2026 request for funding to OHSP. We will hear in the near future about when they plan to allow us to actually apply for that funding. And I anticipate that we will be afforded the opportunity to do that application. We have received award notices and contracts for Branch and Hillsdale County and the medical marijuana grant funding, and we are still waiting for St. Joseph County. The state has not released that contract, but hopefully that will happen soon. The health education staff worked with Coldwater Community Schools to do a presentation with students in middle and high school in regards to vaping. The students were very engaged in the presentations, and the school resource officer indicated that after the presentations, they've seen a decrease in the number of vape alarms that are going off in the schools. So that's encouraging news. We also had a presentation with a health educator and one of our clinic nurses on sexually transmitted infections to the St. Joseph County ISD program, Human Growth Program. These are the adult students program. We will be at Day of the Capitol on April the 9th. And we did have, make application for a hometown healthcare hero award, and we will be, we have a recipient from our jurisdiction who will be recognized at that day. So we're very excited about that. And we do have meetings scheduled with all of our legislators at the state level. We are continuing to work towards our April 25th all-staff meeting. We have the annual report off to the printer. Do you want these shared today or no?
Well, it's still a draft, and you know, we didn't have it ready for program policy and appeals to review, so we will bring it to the next committee meeting, and it will remain a draft until you guys have had a chance to take a look at it.
We continue to work on the opioid awareness program in Hillsdale County, and that planning. We do have a date set, October 16th. It will be held at the Cyril Center on the campus of the Hillsdale College. And the community health worker program is continuing to march along. We've had some good progress as far as additional clients being served. We are continuing to work towards sustainability for the program financially, and that is coming along well. The greatest area of needs continue to be assistance with insurance, assistance with food, financial resources, and people who are experiencing or in threat of experiencing homelessness. It's the end of my report.
All right, any questions? Well, thank you so much. Environmental health.
Good morning. First, I want to introduce Dee Anderson. Dee is our food supervisor that's taking my spot when I bumped up. Dee comes from a line of our industry and some public health as well, and just a vast knowledge. Just really excited to have her part of our team. She's doing a tremendous job. So I just wanted you guys to be able to meet her just in case we have to talk. We're entering a very busy season for both food and well and septic. Food licenses, the food licensing year goes May 1st through April 30th. So today we are mailing out all renewals for food licenses for all 3 counties today. Those will go out. We're hoping to get those back in. It takes a few days. A couple weeks we'll start seeing those come back in, I hope. It's a valuable time when they come back in because we're updating all of Hedgehog, making sure we got great phone numbers, emails, all that, because that does change. They don't necessarily tell us when they bring on a partner or do something wonky. So that's a good time for us to update stuff. We've had one new facility opening, and that is Farron Hall Bakery in downtown Holm. So Farron Hall is a very popular wedding location in Colon area. And so they branched off and started making a bakery. And I assume that that's going very well. They do really kind of recent breads and sweets and stuff. So we've got them up and running. In the well and septic division, we had a training with Eagle and MSUE on the Land Division Act, which is still very confusing. Talking about parcels and breaking them down from a parent to a child parcel and how that all works, which also impacts us when we're dealing with well and septics within subdivisions. So it was a very valuable training. Probably going to definitely go back and review my notes on that one, as well as the rest of the staff. We also have our new clerk has been with us for just over a month, Abby Fader. She's our clerk for St. Joseph County. She spent time in Hillsdale and Branch learning hedgehog and licensing. What's really advantageous for us is she was able to do not only her own food licensing, but she got to do Branch counties for us because our clerk's off on maternity leave. So it was great practice for her to really get involved in it because it's a one time a year thing. So you learn it real quick. It's hot and heavy for about 2 months, and then you don't touch it again for a year. And sometimes you lose some of that. So it's really good practice. And so those are the things we've got going on in environmental health.
All right, thank you. Questions anybody has? All right, good. Okay, we're up to financial reports.
Good morning, commissioners. As you can see, the bills are before you. Not a lot of unusual stuff here. You will see the Maynard Harrison bill. That's part of the commercial payment for the audit. You're also going to see a Michigan Security and Law bill that was dealing with an issue with the Three Rivers door. We had a failure of the hinge on the door there. We had to have them out. So that I only point that out because, you know, we might get confused with the fob work that we had done from the same company that will be on the next one. So other than that, I'd be happy to answer any questions you have.
Make a motion, we approve the payments. Support.
All right, we have motion support. Is there any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? All right, motion carries. Okay, well, financial statements, is there anything?
Yeah, so you have the financials again before you. We have a few programs that's rating a bit high. We are in the process, or just beginning the process of doing a budget amendment, which we hope to bring you in either May or June. We are aware that some things are running a bit over and we're going to need to make some corrections. I have explanations written there. And overall, we're about 6.9% under budget. Be happy to answer any questions.
Okay.
The amount of the state, that seems maybe lower than it has been in the past.
Yeah, they did do some takebacks.
I would move to approve the month-end financial statement as presented.
Support.
All right, we have motion support to approve the financial statements. Any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? All right, motion carries. Okay, so up to committee reports. Finance committee.
Finance committee met, was it Monday? Last Monday. Yeah, last Monday. Met and reviewed the Three Rivers facility interior painting project. Tom and I went through that and decided to recommend it to the full board, went through the offers, the bids, and we will be taking action on that later in the agenda.
All right, sounds good.
Oh, and I'd like to make a motion that we approve the minutes from the finance committee meeting.
I'll support.
Okay, we have a motion for support. Any discussion? I was just gonna comment. I didn't know if we approved all those every time or not, but okay, good to know. Any other discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? All right, motion carries. It's like programs, policies, and appeals did not meet.
We did not.
Anything you wanted to mention under that?
As you know, Commissioner, I had asked the health officer and to put on that agenda to review the health officer evaluation questions. And again, just for having 2 new commissioners on that committee, making sure that they are okay with those questions before we then submit those out to the full board here later this year for that health officer evaluation. I think we heard today that we will be at the May meeting reviewing that annual implementation plan for the area agency on aging as well, so.
Yep, sounds good. All right, so we're up to unfinished business and we have updated wallet cards.
Yeah, so there was an error in the wallet cards that I distributed last month, so I redid them with the correct information, just amended them. If you have last month's, please dispose of it, because it's got a couple of errors.
Gotcha. Well, thank you for that information.
Don't get us confused.
All right, new business. We have the Three Rivers Interior Paint Project.
Yeah. Do you wanna figure it out?
Go ahead.
All right, so we did have several companies bid the project. We did share with all of you the paint specifications that they were all given, that, you know, asked them to submit by a certain date and what we were looking for in each bid. And we reviewed these with the finance committee meeting. We did have 2 bidders that did not submit on time, and that was discussed at the committee meeting. And the recommendation from management was to accept the bid from STP Painting. So I'm happy to answer any further questions you have about that.
I make a motion, we accept the STP bid for the Three Rivers Facility Interior Painting Project.
Okay, we have motion of support. Is there discussion on that?
So the board members know, and I had this conversation with Teresa and Becky via email yesterday. I was disappointed that the bids were not in the packet that was available for the public on the website. I know you guys discussed them at the board finance committee meeting, and that finance committee meeting is recorded and it's on the website, and the numbers, you know, from each bid are indicated there. But there's a demographic of our population today that thinks governmental agencies are trying to hide stuff from the public. And I just think we're better off to not look like we're hiding stuff if we put stuff out on the website, you know, and make that disclosure and share those bids. So that's my only concern and reservation regarding it. And, you know, and maybe we just talked about the program policy and appeals committee, and I think we do have the procurement policy when we do require bids. Maybe something that we need to make sure we spell out and say, I'm sorry if a bid's received late, it's not even looked at, you know?
Yeah.
You know, if we put a deadline that, you know, bids are to be in by this date, if it's not in, it's not in.
In a case like this, probably, I mean, we have a procurement policy that would address like RFP and procedures for that?
We have a procurement policy. I haven't looked at it. And
It's been a little over a year since we looked at it.
And, you know, the rules for what's considered a smaller project, this is considered a small project, so it's not really subject to the full procurement
Gotcha.
policy. So it's much less formal. We ask for quotes. And some of the things that we've dealt with in the past is we haven't been able to get enough quotes to meet a minimum because we couldn't find vendors that wanted to do the work. And
Especially with small jobs, that can be a challenge. Yeah.
that was not the case this time. And the company that was recommended did not submit it quickly, just to be clear. That was.
And again, I listened to that short 10-minute meeting
Yes.
this morning.
You're efficient.
but I do intend to make the bids, put them into the packet after the board votes on it so that they are public. My concern was just that if the commissioners, the whole board wanted more information, my concern was if those bids were public, then people could look at each other's bids if they were asked for additional information or clarify.
Yeah, I get it too. I mean, so probably the hesitation with putting it out there is all that information goes out there prior to even board taking action on it, right? And then everybody has the information about what somebody else bid and all that kind of stuff. So
Well, and that's what I
get
say,
that.
you require those in by a certain date. After that date, that's your bid. We're not looking at changes to it.
Yeah, maybe that's something that could be visited procurement.
And the only thing that I would, I guess, say that we require is evidence of insurance before they begin any work.
Was that was
Said they were bonded on
Well, bonded and insured are two different things.
We ask for additional information before they start. And we'll make sure that you have the certificate of liability.
Yep.
As well as.
Workers' compensation.
Yeah.
Yeah, if they need it. May not need it if they're owner operator, but
Well, but even there would be some additional requirements that they would have to do, especially, I believe that this is an entity. And they would have to have a, BWC 337 signed by state.
something.
So what we need.
Sounds good. Perfect. Good. Any other discussion? All right, hearing none. All those in favor say aye.
Aye.
Any opposed? All right, motion carries. Okay.
May I?
Yes, go ahead.
So the carpet bids, I'm doing those right now. Do we need to have further conversation of program policy and appeals or in finance? I'm not sure which one, about how you want us to present the bids when we get to that point for carpet.
I guess I would just say, bids are due on this day, okay?
And it is, it's on there. It's on the same, just like this.
You know, and then send those to the finance committee to review. Yeah, there are certain things that are followed, you know, and this is where, okay, at times you're gonna get difference of opinion from one carpet person to another as to whether, you know, what threaded carpet, you know, quality, you know, we just, hey, we want, you know, Scotch guard carpet, we, you know, probably looking at carpet squares again compared to, you know, to roll, we want a bid with squares, you know, we want, you know.
And your bid list that you had for paints, I mean, that's good. And obviously, we just want the same thing when we do it.
Right.
The only thing I would say is if there is a procurement policy that we haven't that in a little while, that would be a good thing. Yeah. I mean, I would say either committee, honestly. So
Let's send it over to the.
Well, personnel, it's a policy.
it does CPA or two, but procurement obviously falls under finance.
Well, they have to then follow what we.
All
I think
right,
that
sounds good.
PPA committee meeting might be a little long. Not 10 minutes.
Hey, good luck. Good luck.
All right. Strategic plan update.
Teresa, do you want to do this?
Yeah, so, there's obviously a lot of words on these pages. So what you really want to look at is a green traffic light means we're on track. A gold bar indicates that has been completed. Yellow means it's a little off track and we're working on to correct it. And red means there's something, going. We do have a couple of red lights that we're working on, a couple of yellow. But overall, the plan is moving forward. Some things have been delayed. Nothing is off the table or not doable still, but we continue to work our and to implement it and just report on it.
Okay, great. So everybody's had a chance, hopefully check that out. Thanks for that update on that. Is there any questions anyone has? Or... No. Okay. All right, so we're to our second public comment area. Is there anybody that would like to address the board? Takers on that. Okay. So we'll move on to commissioner comments. Commissioner Collins, let's begin with you.
Appreciate all that you guys are doing and keep up the great work. Appreciate it. You're doing a great job.
I would echo that. Okay, so we're up to adjournment.
Oh, to adjourn.
Support.
Okay, so with the support to adjourn, all those in favor say aye. Opposed? Okay, we are adjourned. Thanks, everybody.
All right.
Thank you.
That was phenomenal, by the way.
Yeah, thank you.
So do you have your car packed and everything? You can just jump in it.
We're holding up Commissioner Hoffman.
I know, right? Yeah, we still got a little bit of packing to do, but for the most part, we are.
Yeah.
For the most.
That's something you can.
Hopefully you have a good one. Yeah, I hope so. I was looking at the weather. It looks like we are. That's a good thing.
Forward to-
Yeah.